Okay, so I guess this is advertised as an open panel, and I gather what that means is that there's general questioning and conversation, not directed to any specific paper or to any of the papers from today, or some synthetic overview. So we're open. The doctor is in to get back to Snoopy. Is there anything? Oh boy. Yes. Okay. Good. Thank you.
If we have moved to an era in which the First Amendment has more limited utility because of the complexity of the technological framework and other factors, accepting that as the premise, what is the remaining role, if any, for the First Amendment? Right? If it's receding, what is it doing in its receded position?
So my reaction to that is something that I sort of muttered about along the way, but and something that Jack suggested very near the end of this last session, which is that it's much more likely to be an obstacle to doing sensible things than it's the sort of it's the business-friendly First Amendment that we're going to be dealing with, at least over the short to medium run. Now, I should say, you know, saying it's going to get in the way of doing sensible things, you know, statists will always say the First Amendment's getting in the way of doing sensible things. It's just the view of what's sensible changes depending on what the politics are. But right now, I mean, I think the the Verizon, and actually because I'm not into this into the telecommunications / internet world very much. For me, the decision by the FDA not to appeal the D.C. Circuit's decision was.
The FDA appealed. You mean the FCC?
No, there are
no, the FDA.
The FDA. Pharma.
The tobacco. The tobacco advertising decision was based. I think nominally, I think they said it was based on the view that what the D.C. Circuit had said was the record that you've developed to support these regulations is not adequate, or because the record's not adequate, we're going to find it unconstitutional. They said, okay, we'll go back and we'll get a better record upon which the constitutionality could be resolved in our favor. But I think a component of that decision must have been advice and consultation suggesting that if they took the case to the current court, it was going to lose. So, I mean, that's the short run kind of thing that the First Amendment is going to impede those kinds of regulatory efforts.
Do you think that's right, that the primary or a remaining role for the First Amendment is as a burden or a hurdle, or is there some background?
So here's the two different analogies. Mark and I both wrote stuff in it was like the late 80s, early 90s on this, and it's all come true. Right? Yeah, damn it. Anyway, but there are two different models. One model is this is just Lochner in cyberspace. So it's this is the due process. This is what happened to the due process clause, which in the Jacksonians is an egalitarian thing. Eventually, during the second half of the 19th century, becomes the vehicle for protection of business interests and the malefactors. And
ideological drift.
Ideological drift. Well, that's where the article came from. And malefactors of great wealth and so forth and so on. So that was the ideological drift of the due process clause. So model A is that. Now today the due process clause does almost no work in the economic sphere, right? And so it's basically just been cast out, and the due process clause gets revivified as being about sexual freedom. Okay, so that's model one. The second model, which I think is actually more appropriate to the First Amendment, is the Equal Protection Clause. The Equal Protection Clause starts out as being basically nothing. And then what happens is, starting in the 40s, it starts to gain some power as a means of promoting a racially progressive agenda and also to protect the rights of women and aliens, etc. And then right around the mid-70s, it flips and there's ideological drift, and the Equal Protection Clause is largely used now to prevent governments from achieving racial integration. So that leads up to parents involved in cases like that. But it's also the case that at the same time that the meaning of the Equal Protection Clause is flipped, so it starts as being pro-integration, it's now anti-integration, you still have the Equal Protection Clause useful in other fields for the protection of gay rights, right? And I suspect, so the due process model is it just runs out of steam and it's no longer useful to anybody for anything. And the equal protection model is it's got these multiple valences that are going on simultaneously. And I think that's what's going to happen in the First Amendment. That is, the business-friendly First Amendment, as Mark would put it, is the First Amendment that will be used to go after public health regulations like tobacco and off-label advertising and restrictions on advertising and campaign finance, and it will be largely used to restore prayer to the public schools. That's the First Amendment that basically is used in order to protect property interests, the interests of religious conservatives and conservative religious mobilizations. But there's another First Amendment, and it'll almost never be used anymore to protect political dissidents. It will never be used to protect labor unions, right? So the same thing has happened in the Equal Protection Clause. But there's also a First Amendment which is about things like access to information. There is a First Amendment which is about a sort of a positive side, or access to government property for purposes of speech. That First Amendment is still hanging around. Right? And that's a First Amendment that you could actually build on. The concern that I have, and I'd be interested in what you think too, Mark, is that will probably be a relatively small proportion of the court's docket for some time to come, because of the combination of who sits on the court and the civil society organizations that are mobilizing to create test cases involving the First Amendment. Most of those civil society organizations are creating test cases involving the business-friendly First Amendment as opposed to these other possible uses of the First Amendment.
Yeah, I'd be less sanguine about the residual. Actually, I have a somewhat different take on the residual effects of the old First Amendment. So with respect to access to spaces, there's all this stuff about, the Occupy cases and the presidential campaign zoning cases, which are the modern versions of the access to geography. And they come out all very badly, right, basically. People might want to have a conversation about this. I think there is a residual effect of the classic. It's a little complicated, but the classic First Amendment, in the evident reluctance to do, on the part of the national government, to do anything more than mutter bad things about newspapers that publish secrets. I mean, they do mutter those bad things, and but the one thing that everybody talks about is the whatever it is,
they would prosecute the New York Times or the Guardian.
And they made no effort to act on the assertion that the recipient of the leak, Risen, that there was probable cause to believe that he had committed a crime. I mean, they asserted that in their legal documents because
to get surveillance.
Right. So okay. So there's, and I think that is a residual effect of the classic First Amendment.
We didn't get a chance. I'd love to ask Rebecca, I'd love to ask you a question on your very intriguing paper, which is to say, what's the image of the First Amendment right? You've got this character who is a decision maker. The agent is a decision maker that combines emotion and rationality. It's very different than the standard liberal story about decision making and autonomy. Is it a concept of power? Is it a concept of autonomy respecting? What's the it you're defending once you accept this emotional, rational character and system?
So, to me, I think endorsing that kind of decider doesn't mean that there aren't facts, right? And so, I think all the action that we should be talking about, at least with respect to commercial speech, should be about fact-finding and the constraints. So whether it's Turner the scrutiny to congressional fact-finding or some other level of scrutiny, figuring out the right level of scrutiny and then figuring out did they meet that in finding the facts, and then the government can actually present facts to you and can present its opinion to you in appropriate circumstances, because we are, as you said, creatures of constraint as well as affordances, and into that mix must come the government one way or the other. I guess that's as far as I've gotten.
I'd love to talk about the Facebook hypothetical. Anybody want to hazard an answer?
Can you do it again?
So put most simply, Facebook discloses quietly, but on the table, that they reserve the right to include in the algorithm any number of things. There's no pretense towards neutrality the way there is in Google search results. And it comes to light that under the terms of that experiment before, a number of votes were swung to one side over the other in an election, courtesy of selective algorithmic delivery of voting encouragement in news feeds, and the election is turned. Is that a problem?
Well, picking up on what Rebecca's paper is saying, it was truthful that the friends of that Facebook subscriber had voted. And so this appeal to their emotions was factual.
Yes, although
It was manipulative, the way that the woman on the mortgage thing was manipulative. It was truthful. There was a woman there. The woman was only establishing that she was there.
But we're trying to draw a line.
It's actually much more truthful than that, right? So there's no, the affect is sort of inherently linked. I think even Professor Corbin would agree that, your friends voted. That's a factual statement.
Yeah.
Yeah.
If they only showed your cute friends.
So, I mean, this is just an immediate reaction, and I make no large claims, but within Rebecca's framework, she did reserve the possibility of a non-speech-based challenge. And maybe there's some political equality challenge that could be brought to against that action, or maybe a better way to put it is maybe legislation barring that could be defended as advancing an interest in political equality, subject to whatever you do with the state action doctrine to license treating this person as subject to a requirement of adherence to political equality.
Wait, no.
Significant difference between what Facebook did and what Fox News does?
Right, exactly. No, I don't think there's any state action problem. I mean, anybody, any private person can say, it could try to influence your vote. Here are people who voted.
No, but I just want to make clear my position. I took Jonathan to be asking, knowing the results of these experiments and fearing the tilted Mark Zuckerberg example, Congress enacts a statute prohibiting Facebook from doing the selective distribution of information.
Right, and so, I mean, then it's like Citizens United. What can Facebook do to influence an election? I don't think there's a state action problem. They have a First Amendment defense, I think, because they would claim all we are doing is what everybody does when they knock on the doors with the orange hats for Howard Dean. Turned out not to work out so well, but look, everybody else is voting for Howard Dean, come join us. Right. They're just doing it more efficiently. I think the only, I mean, so let me answer your, normatively I'm not troubled by it. The only legal argument would be the defense that Facebook, it seems to me, would have, and reasonably so. We are just engaged in trying to persuade people.
See, I think I am troubled by it, and maybe I'm a little troubled by Fox News, but I think Fox News is quite upfront about the fact that fair and balanced is tongue-in-cheek.
And you know what? And as soon as Facebook does this, it will be all over Fox News that Facebook has done it, and Facebook will be known now as the wing of the Democratic Party, the way that Fox News thought to be the wing of the Republican Party.
Yeah.
Or they could do it the other way, and then Fox News will point out what a wonderful thing it is that Facebook is exercising its First Amendment.
All right, and Rachel Maddow then will then say Facebook is now in league with the Republican Party.
That just sounds like assuming away the problem.
I think it's just the nature of electioneering, right? I mean, there's all sorts of things people.
Right. It's just not clear to me that what we're treating, it serves a very different purpose normally in life. People use Facebook all the time, and they think of it as a conduit from them and their friends, rather than as a news station that they're watching, or as somebody that comes up to their door.
So it would be different if it were like a meetup, or organized for like the meetups that were used explicitly this way in 2000. That feels different to you.
So Jonathan and I were talking about this a few moments ago, and Jonathan's core of his hypothetical is the deception. And two examples that happened for real recently in the last 2 weeks. Google had a doodle on the front page that was sort of pro-gay, it was Sonja, and yesterday they did a Valentine's Day doodle, and one of the couples in the cute couple stories was a same-sex couple. And I could have felt very political to me.
They're in the tank for the Democrats.
I was very surprised to see that. Jonathan doesn't have a problem with the upfrontness. His main hypothetical is what if they were doing it secretly on Facebook?
Your hypothetical presupposes that Facebook hasn't, in its terms and conditions, told us.
No. I'm presuming. Of course, anybody is free to adapt the hypothetical. But in my hypothetical, I was presuming that it's not so obviously a false advertising FTC kind of thing. That Google would say, or Facebook here would say, we reserve the right to salt your feed according to any number of metrics. We have no pretense towards neutrality. They do not specifically disclose what they're doing. It is because Mark wants the Democrats to win. And I can't imagine them being required to specifically disclose it any more than Google is required to say how much they got for the sponsored link you're seeing. They just tell you they're sponsored links.
Well,
So-
it turns out that they could. You have to create a new paradigm for platforms. It would be the platform as fiduciary.
Yeah.
So
Right.
if you understand certain kinds of platforms of a certain size performing certain kinds of functions, then you would impose fiduciary duties on the platform. The analogy is the 19th century imposition of common carriage obligations, which are in fact fiduciary kinds of obligations.
I like
on
the sound of
telegraphs,
this,
railroads.
possibly not as much as Susan does, but I like the
Well,
No, I think
let me
there's
just
a
say,
difference between- there's a difference between physical infrastructure and the rest of the stuff. There really is. A difference between a railroad and a telegraph thing and Facebook.
and let me just say,
He's finding out that getting a herd of cats to meow is much easier than getting them to shut up.
let me say, can I say one thing? Can I say one?
We have burritos outside here, and my friends and my Facebook friends across the way are casting me dirty looks for not letting them eat those said burritos. So
Okay.
we should continue. Don't stop. But
Well, I just was, on the common carriage, in the 90s, this was proposed for the dominant carriers then, America Online and CompuServe. They had the dominant position, and they had to be regulated as common carriers.
And there you have Google's answer to this argument.